There's a judgment by Justice Narasimha. I'm sorry, by Justice Bhat, and there's a judgment by Justice Narasimha. So, consistent with the importance of the case, I'll begin by reading out some of our portions. There's a degree of agreement and there's a degree of disagreement on how far one has to go. As I see, the degree of disagreement is on how far we have to go. But I'll read out my judgment, then I'll request Justice Kaul to, I shouldn't say I'll read out my judgment, I'll read out parts of the judgment which are relevant. I've dealt with the issue of judicial review and separation of powers. I'll just briefly refer to some of those extracts. The doctrine of separation of powers, as it is traditionally understood, means that each of the three organs of the state perform distinct functions in distinct spheres. No branch performs the function of any other branch. Actually, Mr. Sibal, Mr. Solicitor, all of you can take a seat. I mean, you don't have to stand to receive the judgment. It will take a little time, so you can all be seated for a bit.
Obliged.
The traditional understanding of this doctrine, also termed the pure doctrine, does not animate the functioning of most modern democracies. That our constitution does not reflect a rigid understanding of this doctrine has long been acknowledged by the court. In practice, a functional and nuanced version of this doctrine operates, where the essential functions of one arm of the state are not taken over by another arm, and institutional comity guides the actions of each arm. In other words, a functional understanding of the separation of powers demands that no arm of the state reigns supreme over another. The Union of India suggested that this court would be violating the doctrine of separation of powers if it determines the list in this case. The separation of powers undoubtedly forms a part of the basic structure of the Constitution, but equally the power of courts to conduct judicial review is also a basic feature of the Constitution. The doctrine of separation of powers certainly does not operate as a bar against judicial review. In fact, judicial review promotes the separation of powers by seeing to it that no organ acts in excess of its constitutional mandate. It ensures that each organ acts within the bounds of its remit. Further, as discussed in the previous segment of this judgment, the Constitution demands that this court conduct judicial review and enforce the fundamental rights of the people. The framers of our Constitution were no doubt conscious of this doctrine when they provided for the power of judicial review. Being aware of its existence and what it postulates, they chose to adopt Article 32, which vests this court with broad powers. The doctrine of separation of powers cannot therefore stand in the way of this court issuing directions, orders, or writs for the enforcement of fundamental rights. The directions, orders, or writs issued for this purpose cannot encroach upon the domain of the legislature. This court cannot make law. This court cannot make law. It can only interpret it and give effect to it. Page 73 पर एक correction है. Then I'm dealing with now in another segment of the judgment, which is titled Queerness is not Urban or Elite. The discussion in this segment has not scratched the surface of the rich history of the lives of LGBTQ persons in India, which continue into the present. Yet even the limited exploration of the literature and reportage on the subject makes it abundantly clear that homosexuality or queerness is not solely an urban concept, nor is it restricted to the upper classes of privileged communities. The discussion in the preceding paragraphs reveals the diversity of the queer population. People may be queer regardless of whether they are from villages, small towns, or semi-urban and urban spaces. Similarly, they may be queer regardless of their caste and economic location. It is not just the English-speaking man with a white-collar job who lives in a metropolitan city and is otherwise affluent who can lay claim to being queer, but also and equally the woman who works in a farm in an agricultural community. Persons may or may not identify with the labels queer, gay, lesbian, trans, etc., either because they speak languages which are not English or for other reasons. But the fact remains that many Indians are gender queer or enter into relationships with others of the same sex. In the words of a person assigned female at birth who worked at a factory in Ajmer, and I've quoted to imagine queer persons as existing only in urban and affluent spaces is to erase them, even as they exist in other parts of the country. It would also be a mistake to conflate the urban with the elite. This renders invisible large segments of the population who live in urban spaces but are poor or otherwise marginalized. Urban centers are themselves geographically and socially divided along the lines of class, religion, and caste, and not all those who live in cities can be termed elite merely by virtue of their residence in cities. This walk through history is not an attempt by this court to take on the mantle of historians. The discussion demonstrates that the institution of marriage has not remained static or stagnant. To the contrary, it is change which characterizes the institution. All social institutions transmogrify with time, and marriage is no exception. From sati and widow remarriage to child marriage and intercaste or interfaith marriages, marriage has metamorphosed. The institution as we know it today would perhaps be unrecognizable to our ancestors from 200 years ago. Despite vehement opposition to any departure from practice, the institution of marriage has changed. This is an incontrovertible truth. Here it is also important to take note of the fact that these changes were brought about largely by acts of parliament or the legislatures of the states. While the passage of many laws was preceded by significant social activism, it was the legislature which ultimately responded to the call for change. Even as parliament and in some cases the courts expand the liberties of the people to conduct their lives in a manner they see fit in accordance with law, many sections of society remain opposed to these changes. Regardless of such opposition, the institution of marriage has undergone a sea change. It is therefore incorrect to characterize marriage as a static, stagnant, or unchanging institution. Fundamental rights are not merely a restraint on the power of the state, but provisions which promote and safeguard the interests of the citizens. They require the state to restrain its exercise of power and create conducive conditions for the exercise of rights. If such a positive obligation is not read into the state's power, then the rights which are guaranteed by the Constitution would become a dead letter. This is because the question of whether the state is curtailing the rights of citizens would only arise if the citizens have the capacity and capability to exercise such rights in the first place. The withdrawal of the state from the domestic space leaves the disadvantaged party unprotected, since classifying certain actions as being private has different connotations for those with and without power. In the case of personal relationships which are characterized by inequality, the actions of the more powerful person gains immunity from scrutiny and a degree of legitimacy. Thus, all activities in the private space dealing with intimate choices must not readily and blindly be categorized to be beyond the scope of the state's regulation. The state must assess if its interest in democratizing the private space overrides the interests of privacy in a given situation. In pursuance of the power conferred by Articles 245 and 246, read with entry 5 of the concurrent list, Parliament has enacted laws creating and regulating socio-legal institution of marriage. The state legislatures have made amendments to such laws with the assent of the President, since the subject of marriage is in the concurrent list. The petitioners seek that the court recognize the right to marry as a fundamental right. As explained above, this would mean that even if Parliament and the state legislatures have not created an institution of marriage in exercise of their powers under entry 5 of the concurrent list, they would be obligated to create an institution because of the positive postulate encompassed in the right to marry. This argument cannot be accepted. As explained in the previous section, the state through the instrument of law characterizes marriage with two constituent elements, the expressive component and the material component. Marriage may not have attained the social and legal significance it currently has if the state had not regulated through law. Thus, while marriage is not fundamental in itself, it may have attained significance because of the benefits which are realized through regulation. If the court finds that a provision is contrary to Part 3 of the Constitution, it shall declare that it is void, or read it down by deleting phrases, or read words in by adding or substituting phrases to save it from being declared void. If in the present batch of petitions, this court holds that Section 4 of the Special Marriage Act is unconstitutional because it is under-inclusive to the extent that it excludes, by implication, marriage between same-sex couples, the court would either strike down Section 4 of the SMA or follow the workability model submitted by the petitioners. If the court follows the first approach, the purpose of a progressive legislation such as the SMA would be lost. The SMA was enacted to enable persons of different religions and castes to marry. If the SMA is held void for excluding same-sex couples, it would take India back to the pre-independence era, where two persons of different religions and castes were unable to celebrate love in the form of marriage. Such a judicial verdict would not only have the effect of taking the nation back to the era when it was clothed in social inequality and religious intolerance, would also push the courts to choose between eradicating one form of discrimination and prejudice at the cost of permitting another. If this court takes the second approach and reads words into the provisions of the SMA and provisions of other allied laws such as the Indian Succession Act and Hindu Succession Act, it would in effect be entering into the realm of the legislature. The submissions of the petitioners indicate that this court would be required to extensively read words into numerous provisions of the Special Marriage Act and other allied laws. The court is not equipped to undertake an exercise of such wide amplitude because of its institutional limitations. This court would in effect be redrafting the laws in the garb of reading words into the provisions. It is trite law that judicial legislation is impermissible. We are conscious that the courts usually first determine whether if the law is unconstitutional and then proceed to decide on the relief. However, in this case, an exercise to determine whether the SMA is unconstitutional because of under-inclusiveness would be futile because of the limitations of this court's power to grant a remedy. Whether a change should be brought into the legislative regime of the SMA is for Parliament to determine. Parliament has access to varied sources of information and represents in itself a diversity of viewpoints in the polity. The court, in the exercise of the power of judicial review, must be careful not to tread into the legislative domain. It is clarified that this court has not adjudicated upon the validity of any laws other than the SMA, the FMA, the adoption regulations, and the Kara circular. Page 153 पे correction था. The understanding of the Constitution, then I've said the goal of self-development and what it means to be human. This understanding of the Constitution is substantiated on the reading of Part 4 of the Constitution. To illustrate, Article 38 states that the state shall strive to promote the welfare of people. Then I've referred to Article 42 and Article 47. The Constitution, through both positive and negative postulations, inter alia capacitates citizens in their quest to develop themselves. Such capacity building enables them to achieve their full potential in both the private and the public space and to be happy. The Indian Constitution, unlike, say, the South African Constitution, does not expressly provide that the Constitution seeks to improve the quality of life and free the potential of each person. However, such an understanding can be gleaned from the provisions of Part 3 and Part 4. Thus, one of the purposes of the rights framework is to enable the citizenry to attain the goal of self-development. Humans are unique in many respects. We live in complex societies, are able to think, communicate, imagine, strategize, and to do more. However, that which sets us apart from other species does not by itself make us human. These qualities are necessary elements of our humanity, but taken alone, they paint an incomplete picture. In addition to these qualities, our ability to feel love and affection for one another makes us human. We may not be unique in our ability to feel the emotion of love, but it is certainly a fundamental feature of our humanity. We have an innate need to see and to be seen, to have our identity, emotions, and needs fully acknowledged, recognized, and accepted. The ability to feel emotions such as grief, happiness, anger, and affection, and the need to share them with others makes us who we are. As human beings, we seek companionship, and most of us value abiding relationships with other human beings in different forms and capacities. These relationships may take many forms: the natal family, cousins and relatives, friends, romantic partnerships, mentors or students. Of these, the natal family as well as the family created with one's life partner form the fundamental groups of society. The need and ability to be a part of a family forms a core component of our humanity. These relationships, which nourish the emotional and spiritual aspects of our humanity, are important in and of themselves. Further, they are as important to self-development as the intellectual and eventually financial nourishment we receive through education. Self-development cannot be measured solely in terms of educational qualifications and financial capabilities. Such a description is to forget what makes us human. It is insufficient if persons have the ability and freedom to form relationships unregulated by the state. For the full enjoyment of such relationships, it is necessary that the state accord recognition to such relationships. Thus, the right to enter into a union includes the right to associate with a partner of one's choice, according recognition to the association, and ensuring that there is no denial of access to basic goods or services, which is crucial to achieve the goal of self-development. On the other hand, the state could indirectly infringe upon the freedom when it does not create sufficient space to exercise that freedom. A formal associational status or recognition of the association is necessary for the free and unrestricted exercise of the freedom to form intimate associations. Needless to say, there may be reasonable restrictions on this right. However, other than legally valid and binding restrictions, the right to intimate associations must be unrestricted. The state, by not endorsing a form of relationship, encourages certain preferences over others. In a previous segment of this judgment, we have discussed the tangible and intangible benefits of recognizing relationships in the form of marriage. While the tangible benefits of marriage are traceable to the content of law, the intangible benefits are secured merely because the state recognizes the relationship through the instrument of law. Intangible benefits in the form of expressive advantages exist irrespective of the content of the law. Even if the law does not grant any special material benefits to a relationship, the relationship would still be considered to be legitimate in the eyes of society. The freedom to choose a partner and the freedom to enjoy their society, which are essential components of the right to enter into a union and the freedom of intimate association, would be rendered odious if the relationship were to be discriminated against. For the right to have real meaning, the state must recognize a bouquet of entitlements which flow from an abiding relationship of this kind. A failure to recognize such entitlements would result in systemic discrimination against queer couples. Unlike heterosexual couples who may choose to marry, queer couples are not conferred with the right to marry by statute. To remedy this, during the course of the hearing, the Solicitor General of India made a statement that a committee chaired by the Cabinet Secretary will be constituted to set out the rights which will be available to queer couples and unions. The committee shall set out the scope of the benefits which accrue to such couples. I've traced the right to form unions through a variety of provisions of the Constitution, and I'll refer to Article 19(1)(e) among other things. Citizens of India have the right to settle in any part of the territory of India in terms of Article 19(1)(e). They, like all other citizens, may exercise this right in two ways. First, they may build their lives in a place of their choosing in accordance with law, either by themselves or with their partner. They may reside in that place permanently, subject to other reasonable restrictions, including those intended to protect the rights of tribal communities. This right is uniquely significant to persecuted groups, such as queer persons, intercaste couples, or interfaith couples, who migrate from their hometowns to other places in the country, including cities. And second, they may settle down with another person by entering into a lasting relationship with them. In fact, this mode of the exercise of the right under Article 19(1)(e) is encompassed by the first mode, because to many people, building a life includes choosing their life partner. Hence, the right to enter into a union is also grounded in Article 19(1)(e). Article 21 is available to all persons, including queer persons. Article 21 encompasses the rights to dignity, autonomy, and privacy. Each of these facets animates the others. It is not possible to speak of the right to enter into a union without also speaking of the right to intimacy, which emanates from these rights. Page 170 note kar do. These rights demand that each individual be free to determine the course of their life as long as their actions are not barred by law. Choosing a life partner is an integral part of determining the course of one's life. Most people consider this decision to be one of the most important decisions of their life, one which defines their very identity. Life partners live together, spend a significant amount of time with one another, merge their respective families, create a family of their own, care for each other in times of sickness, support one another, and much more. Hence, the ability to choose one's partner and to build a life together goes to the root of the right to life and liberty under Article 21. Undoubtedly, many persons choose not to have a life partner, but this is by choice and not by a deprivation of their agency. The law constrains the right to choose a partner in certain situations, such as when they are within prohibited degrees of relationships or are in a consanguineous relationship. All persons, including members of the queer community, have the right to judge the moral quality of the actions in their own lives, and having judged their moral quality, have the right to act on their judgment in a manner they see fit. This attribute is, of course, not absolute and is capable of being regulated by law. In the segment of this judgment on the right to life and liberty, this court noticed that the meaning of liberty is, at its core, the ability to do what one wishes to do and be who one wishes to be in accordance with law. All persons may arrive at a decision regarding what they want to do and who they want to be by exercising their freedom of conscience. They may apply their sense of right and wrong to their lives and live as they desire in accordance with law. Some of the decisions, the moral quality of which they will judge, including the decision on who their life partner will be and the manner in which they will build their life together. Each individual is entitled to decide this for themselves in accordance with their conscience. This court has recognized that equality demands that queer persons are not discriminated against. An abiding cohabitational relationship, it includes within its fold a union of two individuals, cannot be discriminated against on the basis of sexual orientation. Material and expressive entitlements which flow from a union must be available to couples in queer unions. Any form of discrimination has a disparate impact on queer couples who, unlike heterosexual couples, cannot marry under the current regime. When Article 15 is read in a broader manner indicated above, the word sex in Article 15 takes within its meaning sexual orientation, not only because of the causal relationship between homophobia and sexism, but also because sex is used as a marker of identity. The word sex cannot be read independent of the social and historical context. Thus, sex in Article 15 includes within its fold other markers of identity which are related to sex and gender, such as sexual orientation. Thus, a restriction on the right to enter into a union based on sexual orientation would violate Article 15 of the Constitution. The gender of a person is not the same as their sexuality. A person is a transgender person by virtue of their gender identity. A transgender person may be heterosexual or homosexual, or of any other sexuality. If a transgender person is in a heterosexual relationship and wishes to marry their partner, and if each of them meets the other requirements set out in the applicable law, such a marriage would be recognized by the laws governing marriage. This is because one party would be the bride or the wife in the marriage, and the other party would be the bridegroom or the husband. The laws governing marriage are framed in the context of a heterosexual relationship. Since a transgender person can be in a heterosexual relationship like a cis male or a cis female, a union between a trans woman and a trans man, or a trans woman and a man, or a trans man and a woman can be registered under the marriage laws. The transgender community consists of inter alia transgender men and transgender women. A transgender man has the right to marry a woman under the laws governing marriage in the country, including personal laws. Similarly, a transgender woman has the right to marry a man. A transgender man and a transgender woman can also marry. Intersex persons who identify as a man or a woman and seek to enter into a heterosexual marriage would also have a right to marry. Any other interpretation of the laws governing marriage would be contrary to Section 3 of the Transgender Persons Act and Article 15 of the Constitution. Now I've gone to the CARA regulations, Regulation 5.3 of the adoption regulations, and I've said that Regulation 5.3 of the adoption regulations exceeds the scope of the JJI. However, Regulation 5.3 of the adoption regulations bars unmarried partners from being prospective adoptive parents. These regulations only permit persons to adopt in an individual capacity and not jointly as an unmarried couple. Regulation 5.2 states that every person, irrespective of whether they are married or unmarried, will be able to be prospective adoptive parents. The subsequent criteria in Clause A, that is the requirement for the consent of both spouses if they are married, does not exclude an unmarried couple from adopting. It only states that if a couple is married, then the consent of both the parties shall be secured. However, Regulation 5.3 in express terms excludes unmarried couples from adopting by prescribing the condition that the couple must have been in 2 years of a stable marital relationship. Page 210. As observed in the previous paragraph, the Juvenile Justice Act does not preclude unmarried couples from adopting. Though Section 57 of the Act grants CARA the power to prescribe additional criteria, the criteria must not exceed the scope of the legislative policy. Neither the general principles guiding the JJ Act nor Section 57 in particular preclude unmarried couples from adopting a child. In fact, all the other criteria ensure the child's best interest. The Union of India has not proved that precluding unmarried couples from adopting a child, even though the same people are eligible to adopt in their individual capacity, is in the child's best interest. Thus, CARA has exceeded its authority by prescribing an additional condition by way of Regulation 5.3, which is contrary to the tenor of the Juvenile Justice Act and Section 57 in particular. The adoption regulations use marriage as a yardstick to classify couples. There is an intelligible differentia in using marriage as an indicator to classify couples in the sense that married couples can easily be distinguished from unmarried couples. However, the differentia does not have a rational nexus with the object sought to be achieved by the CARA regulations, which is to ensure that the best interest of the child is protected. Placing a child in a stable family is undoubtedly in pursuance of a child's interest. However, the respondents have not placed any data on the record to support their claim that only married relationships can provide stability. It is true that separating from a married partner is a cumbersome process when compared to separating from a